Executive Director here at Georgia Equality. I'll be joined by Corey Isaacson with ACLU of Georgia and Dr. Jason Schneider. We will be open for questions after we make some brief comments. We at Georgia Equality, and on behalf of the organizations that we work with and members of the LGBTQ community here in Georgia we serve, we are devastated and heartbroken by today's U.S. Supreme Court decision in U.S. versus Skrmetti. While we knew this was a possibility, we certainly held out hope that we would have a different ruling from the U.S. Supreme Court on this. But some points that I think it's important as top lines to remember as we go forward is that, first of all, this ruling does not change the science behind the medical care for transgender individuals, including transgender youth, or the relief that it provides those youth and their families. It's also important to keep in mind that ultimately we feel that today's ruling is very narrow. While it certainly talks about the Tennessee case and the ban on gender-affirming care in our sister state, this decision casts little, if any, light on how a majority of justices will analyze or rule on other issues such as sports bans, the transgender military ban, or restrictions affecting schools, prisons, or government IDs. Those cases involve express discrimination against transgender people, which today's majority decision was careful not to address. It's also encouraging that the majority opinion is very respectful of transgender identity and refers to transgender people with appropriate nouns and pronouns. We remain hopeful that in the future, a majority of the justices will affirm the protections and rights of transgender people in other contexts. This ruling specifically did not have an immediate impact on the precedents that was set by the decision in Bostock versus Clayton County a couple of years ago. With that, I'd now like to turn it over to my colleague, Corey Isaacson with ACLU of Georgia, to talk through the legal implications here in Georgia.
Hi, everybody. Thanks so much for joining us. Thanks, Jeff, for opening us up. I know that this decision is really devastating for a lot of people, and it impacts the real lives of real individuals. So while we're talking about some of the legal implications, some of the policy implications, it's important to keep top of mind that there are young people and their families across the country who are really severely and directly impacted by this decision, and are really devastated by it. To add on to what Jeff just opened with, this is a very disappointing decision in so many ways. At the same time, there is some hope and some narrowness in the decision that we are grateful for, and that we think creates avenues to continue challenging discrimination against transgender individuals in the future. We think that the Supreme Court got this really wrong here, and that their reasoning and their findings in this opinion are just wrong on their face. What the Supreme Court essentially does here is say that the ban against gender-affirming care for young people, Tennessee's ban on gender-affirming care for young people, is not at all discriminating or categorizing on the basis of transgender status. Instead, what it is doing is making distinctions based on medical diagnosis. So what they essentially say is, this is not about saying young people who are transgender cannot have access to this care, but young people who are not transgender can have access to this care. Instead, how the Supreme Court frames it is, all the ban is doing is saying people with this medical diagnosis, gender dysphoria, cannot receive this care. People who have a different diagnosis, for instance, delayed puberty, can access this care. we think this is a really disingenuous way to look at the law and to analyze it. There's clearly a very close connection between the medical diagnosis of gender dysphoria and someone's status as being transgender. And that is something that the Supreme Court essentially pretends not to see and saying that the ban is not about discrimination against transgender individuals. So we think they got it very clearly wrong here. At the same time, as Jeff was saying, there are some windows of hope in the decision. They did not foreclose Bostock being applied in context beyond Title VII. That they reserved ruling on that. They left open the real possibility that the court would not be okay with intentional discrimination against transgender individuals. They felt that this Tennessee ban was not intentional discrimination against transgender people, but they very much left open the possibility that if a challenge were to come along that did involve what they felt like was intentional discrimination, that very well may be something that the court would not sanction. So there are windows for hope within this devastating opinion. As far as the implications on Georgia in particular, we do have a pending challenge against SB 140, which is the gender affirming care ban that was passed in Georgia. And that litigation has actually been on hold pending the Supreme Court decision in Skrmetti. So that litigation will now return to being active now that Skrmetti has come out. And, we have a couple of different options in terms of what the next steps in that litigation will look like. But there will be some movement in that case soon. But Skrmetti has a big impact on what that litigation looks like and on that current challenge. And with that, I will pass it on to Dr. Schneider to talk more about, the actual people who are impacted by this decision and the science and necessity behind gender affirming care. Thanks so much.
Thank you. Yes, thank you, Corey. I just want to dovetail on many of the points that Jeff and Corey have already made, that this unfortunate decision doesn't erase the existence of trans and gender diverse youth and their families and the ongoing care that they will need. And just to, again, debunk myths that are out there about gender affirming care, there's no such thing as hormones on demand. Trans and gender diverse kids can't walk into a clinic and leave with a prescription, nor can they walk in and get gender affirming, surgical care that day. These healthcare decisions are made in consultation with multidisciplinary care teams, the youth's family, and the youth themselves, and that's where it should remain. These should be private decisions made by health professionals, patients, and their families. And this care is not experimental. Far from that. And just today, the American Academy of Pediatrics issued a statement reaffirming the evidence base and the importance of maintaining access to gender affirming care. And I wanted to highlight an authoritative report, actually, that was commissioned by the Utah legislature that was published last month, an exhaustive systematic review of the literature, over 1,000 pages, debunking the myth that there is not good data actually, and quoting the article, results from our exhaustive literature searches have led us to the opposite conclusion, that there is good literature out there now. And quoting again from that exhaustive and authoritative report, the consensus of the evidence supports that the treatments are effective in terms of mental health, psychosocial outcomes, and the induction of body changes consistent with the affirmed gender in pediatric patients. And the evidence also supports that the treatments are safe in terms of changes to bone density, cardiovascular risk factors, metabolic changes, and cancer. So continuing to subject youth to gender dysphoria worsens health outcomes, especially mental health ones. And we have a growing body of evidence that access to seeking an access to gender affirming care improves health and saves lives. So I'll stop there with my formal remarks and I'd be happy to take questions.
Thank you, Dr. Schneider. Just in closing, I would like to actually quote from Justice Sotomayor's dissent, and that is, by retreating from meaningful judicial review exactly where it matters most, the court abandons transgender children and their family to political whims. In sadness, I dissent. We couldn't agree more with Justice Sotomayor. We are now open for questions.
Well, I'll go ahead and start. Raul Valley, WABE Radio. Corey, walk us more through the process of the challenge to Georgia's law. And does this mean we got a hearing coming up? Just walk a little more kind of on the nuts and bolts around the case?
Sure. So we filed this case right before SB 140 went into effect and got a pretty swift ruling from the court, from Judge Sarah Garrity, issuing a preliminary injunction and stopping the law from going into effect. There was a somewhat similar challenge to an Alabama law that was pending in the 11th Circuit around the same time. And so Judge Garrity's order enjoining the Georgia law was then stayed pending the outcome of this 11th Circuit appeal of the Alabama law, and then was stayed again pending the outcome of Skrmetti, because there are overlapping legal claims, and so the Supreme Court's decision in Skrmetti is, impacts the legal claims in some ways in the SB 140 challenge. So Rahul, I know that's a long-winded way of saying we're not sure what's going to happen next, but we do know that the litigation will return to some kind of active status now that Skrmetti has come out, and we need to figure out as a litigation team what our options are and what potential avenues might still be available in the post-Skrmetti world. So, what the next steps are and what the near future in that case looks like are up in the air now, but there will be movement soon now that Skrmetti has come out.
Thank you.
Hey, it's Maya at AJC. I was curious if, I know in other challenges of other state laws that ACLU has been part of, there have been differences between Georgia's law versus some of the other states. And so I was curious how closely Georgia's law mirrors Tennessee's. Specifically, did they have the kind of grandfathered pieces that we have in Georgia, and what effect that does or doesn't have on your case here?
Thanks, Maya. I actually don't know the answer to that question, so I'm not going to guess. I actually don't remember if that detail that we have in the Georgia law, which essentially allowed care that had started, I think, before July 1st, 2023, to people who had started care before that date are allowed to continue care under SB 140. I actually don't know if a similar provision is in the Tennessee law, but I'll look into that and see. I think there are distinctions between the Georgia law and the Tennessee law, and different states' bans generally with the Georgia law and in between states, there are also overlapping similarities and almost all of them. And so whether the distinctions are meaningful for purposes of continuing to litigate this challenge after Skrmetti, is something we'll be figuring out as we move this litigation forward.
Thank you.
If I could add to that, thank you so much for that, Corey. We also know that there's pending legislation still here in Georgia, and we will be fighting hard to oppose that legislation when it comes back up in 2026. There is nothing in this opinion that should be taken by legislators as a mandate. It may have given them the authority to do this, but that doesn't make it right. That doesn't make it moral. That does not create a sense of urgency where none exists. As Dr. Schneider already walked us through, the potential harms to kids, taking away the rights of parents to make medical decisions for their families. All of those are still real threats to Georgians. And these are all issues that are still undecided by the legislature. The Supreme Court, I would say, merely deferred to the legislature and just reasserted their ability to make some of these decisions. But there's still a lot of issues, and we will continue to fight them in the legislature, and we will continue to work with our legal partners like the ACLU of Georgia to fight these in the courts.
A question for Dr. Schneider. Dr. Schneider, I don't know you. Do you practice in this area? And whether it's the passage of 140 or this case, how has this been affecting your practice? Have you been getting questions? That's what I'd love to hear from you.
So I provide gender affirming care to adults in the Metro Atlanta community, although I'm working close partnership with youth providers in our area. And even the threat that came from the executive actions from the administration about threats of withholding federal funding and GME fund, graduate medical education funding for providing care for those under 19, have led to area clinics shutting down access for those that are between ages 18 and 19. But anyway, even though I don't provide that direct care, I am familiar with the struggles of both provider and patients and their families in the Metro Atlanta area, where families are active, if they have the privilege of doing so, are relocating from the state. They are there's active conversations about detransitioning kids that are currently that may be just about to start or have started gender affirming hormones. So even in a hypothetical sense, so Georgians are being directly impacted. Georgia kids and their families are being directly impacted by what's happening at the federal level. And yeah, so that's exactly as Jeff said. We have to be prepared for continued legislative fights come next year under the Gold Dome.
And then one more for me, Mike. This is probably for Jeff, and I probably know the answer to this question, but I was curious what you're hearing from parents, in these hours since that ruling was made, and what kind of the general reaction has been.
Yeah, well, folks, as I said, folks are feeling devastated. Folks are feeling heartbroken. It's not a good day. I think we had all hoped that we would have a better decision, a different decision, a more thoughtful decision. from the Supreme Court. While it's important to point out the realities of the narrowness and that this is not a broad mandate, because I do think that there are folks that are going to take this decision and try to distort it to make it sound like it is a mandate, to make it sound like it is a very broad ruling against transgender individuals across the board. And that's why it's important to get that message out. But it's also important to recognize the feelings that members of the transgender community are having, the concerns that parents will have about whether or not it is safe to continue to raise their families here in Georgia. Where will they go for medical care if the ACLU of Georgia's lawsuit against SB 140 is ultimately not successful? What will happen to their families and their medical futures, their ability to make decisions, if we see action to further restrict access to medical care for transgender youth? There is just a lot of sadness, fear, and anger that's out there in the community right now. I'm sorry that we were not able to get any of the parents with us today. I do want to point out we will be having a community gathering at Saturday because it is important to come together as a community. And so we will have parents there. We will have members of the transgender community there at that community gathering on Saturday to share their stories, to find comfort in community, and hopefully find the resolve to continue to fight the fight that we need to fight.
And I'm not sure if you sent it already, but can you just make sure that we get the information on that gathering?
Yeah, it's taking place at 10 o'clock. I'll need to confirm the location since we weren't sure exactly what Saturday we would be doing this. Information is just going to be getting out later today.
Okay, thank you.
We did have one question on the live stream chat from Ross Williams with the Georgia Recorder for Dr. Schneider. He asked if this will change the way that you and other doctors in Georgia treat your patients.
Well, yes, particularly for youth providers, we we have to follow the law, right? So but adult care has not been affected. So yeah, I mean, right now there is a big kind of divide at that age of 18 that to which Georgia providers, prescribers must adhere. So I hope I'm understanding and answering the question.
But Dr. Schneider, but that is just for hormone replacement therapy. Puberty blockers, other forms of care are still accessible here in Georgia.
Thank you for that clarification. Yes, but there is still, it is important to note there is harm in just being given access to puberty blockers alone. Prolonged care or pausing of puberty is harmful in both physical and mental ways. So it's not a sustainable approach for gender diverse youth in our state.
Are there any other questions? Okay, I want to thank Dr. Schneider. I want to thank Corey, and thank you all for being here today. More information is available as it comes out.
So much.
Thank you.